Well, Jacob, thanks again for your time this evening, sir. Great talking to you.
You're welcome.
You've got a piece at Reason. Does the backlash against stand your ground laws make sense? We've seen down in Florida, Governor Rick Scott has appointed a task force that, it should be mentioned, has both pro and anti-gun individuals on it to take a look at stand your ground. You point out some of the other things that are going on around the country. And certainly, I think more than anything, the media, a lot of the newspapers around the country have been calling for revisiting stand your ground laws. What do you think about this?
Well, it's sort of puzzling because this is all supposedly stemming from the Trayvon Martin case, but it doesn't seem like the most prominent aspect of these laws, which is the part that gives them their name, the stand your ground part, actually has anything to do with that case. Because as Zimmerman describes the fight, and he may or may not be telling the truth, but as he describes it, he had no opportunity to retreat. So even if the standard were the old duty to retreat in public places, which is what it was prior to 2005 when they changed the law in Florida,
right?
It wouldn't have mattered because he says that he was in a fight where he feared his life. Martin was on top of him, going for his gun or thinking about going for his gun, and he feared for his life, and he shot him in order to prevent him from killing him or seriously injuring him. So that's now, may or may not be true, but that's his story. It has nothing to do with stand your ground. Stand your ground would only apply in a situation where there was an opportunity for him to get away, and he didn't take advantage of that opportunity.
Absolutely. And so, given that, as you say, under both of these scenarios, stand your ground really doesn't enter the picture, what do you think is really going on here, Jacob? Is this just, a go for the opportunity to attack a law that the NRA, thinks is a good law and a law that, has been put on the books in a lot of states over the past few years?
Well, I think there is, that's a part of it for sure. There are people who don't really like these laws, didn't like them to begin with, and are using this as an excuse. But I think there's also some genuine confusion. If you look at the way this story has been reported in the New York Times over and over again, they report it in a way that is either flat out wrong or very misleading, because they keep talking about the broad leeway that the stand your ground law gives, and they imply that's the reason it took so long to arrest Zimmerman, and that because of this he might get off, and so on. And while really stand your ground per se had nothing to do with him being arrested or not being arrested, as far as we can tell, given the account that he gave police, the one thing that might have made a difference is that under Florida's law, you have to show probable cause, which is not unusual. That's what you usually have to show when you're arresting somebody. But what's different about it is that in many states, probable cause in a homicide case only applies to the fact that a homicide happened and you did it. And then once you're arrested, you can use, you can say you acted in self-defense in order to defend yourself against the charge. But in Florida, the way it works is that they have to have probable cause not only that the homicide occurred and that you did it, but also probable cause to believe that you were not actually acting in self-defense. It was not a lawful homicide. In other words, that this was actually a crime, that a crime was committed. So, you can argue over whether that's a good idea or not. It seems pretty logical to me, given that that's the standard that is applied for arresting people for any other crime. But the fact that they needed probable cause obviously is something of a burden on the police. It's designed to be a burden on the police. But arguably, this really has more to do with an inadequate investigation than anything else, because as we saw, once the resources are really brought to bear as a result of all this public attention, in fact, they did decide they had probable cause. They looked into it a little bit more, and they decided they had probable cause. They arrested him, and now he's going to face a pretrial hearing, and later on, assuming he doesn't prevent the trial at the pretrial hearing, he'll go to trial. So that aspect of it might have made a difference, but the resolution of the case is not going to hinge on any special permission that Florida law gives you to kill people. Assuming at the pretrial hearing, what he's going to do is he can try to show by a preponderance of the evidence, which means it's more likely than not that he acted lawfully, that he was acting in self-defense. He can try to convince a judge of that by telling his story, presenting whatever evidence he has. If the judge is not convinced by that standard, then he will go to trial. And as in any trial, the prosecution has the burden of proving that he's guilty beyond a reasonable doubt, which means they have to attack his self-defense story and convince the jury that it's not really true. So again, that's not unusual. That's virtually every state. That would be the case, that once you actually get to the trial, the prosecution has to prove beyond a reasonable doubt that you were not acting in self-defense.
Right.
So none of that really is special about Florida. The pretrial hearing is unusual, but if he can already show by preponderance of the evidence that he acted in self-defense, well, that's way more than reasonable doubt. I mean, that's, if he actually, 51%, you're 51% sure that he acted illegally, then that's way more than you need for reasonable doubt. So it makes sense that he wouldn't go on to trial if he were able to show that. But everything else is as criminal trials are usually handled, and the Florida case is not that unusual.
Yeah, absolutely. We're talking with Jacob Sullum from Reason Magazine. And, some of the other things, Jacob, that I've seen that haven't been pointed out, I mean, I guess you've seen stories here and there, but by and large, the anchors aren't reporting on this. Like California has had Stand Your Ground for over 100 years now, I understand. There are some states that have Stand Your Ground kind of baked into the state constitution or their state statutes. So there haven't been legislative changes. This law is not unusual. This law is not new. And again, this law is not at issue here. It is, you have to wonder at this point, like, are the reporters just not interested in reporting on what really is going on here, or is this an excuse to trash a pro self-defense law? It's not even a pro gun law. It's just a self-defense law. Guns.
Absolutely. Yeah. I mean, I think a lot of people were unhappy with this law, including lots of prosecutors. Not surprisingly, when you make a prosecutor's life more difficult, they tend to object to that. So the New York Times, I remember, had a story in the early going when this case first became a national story, saying, "Oh, prosecutors hate this law." I'm like, well, no kidding. Of course, prosecutors hate the law. It makes their life harder, but it doesn't mean it's a bad law. They have to go. Have to work a little bit harder, to prove their case. And if that's true, then what that means is that in some situations it is making a difference. The question has always been, is it really true that sometimes, this is the only scenario where this applies that's relevant to this case is in a public place. So you're in a public place, you used to have a duty to retreat. That meant that you had to show that it wasn't reasonable to expect you to retreat, that it wasn't safe to do so, or there wasn't an opportunity to do so. And the people who argued to change the law said that that's an unreasonable burden. It's not fair to expect that of somebody who is defending his life in a place where he has every right to be, why should he have to show that there was no escape route? And it's not clear that it really makes that much difference, though, because the old standard was, you had to show you reasonably believe that there was no safe way to escape. Mm-hmm. Now you have to show that you reasonably believe that your life is in jeopardy or you're at the risk of serious injury. There's still a burden on you to make some kind of showing that this was reasonable in the circumstances, and that's what's often lost. When the New York Times reports on what the law says, it will often say, the law says that if you think somebody's a threat, you can kill them.
Right.
That's not true, because crucially, you have to reasonably believe that they pose either a deadly threat or a threat of serious injury, and that's what in the first place police are going to evaluate, then the prosecutors, and ultimately, probably in this case, a jury will evaluate, was it reasonable for him to believe that in those circumstances?
And that's what's so frustrating about and I guess you do see this in reporting as well, but certainly the punditry has just gone nutty about this. I mean, I've just seen some ridiculous things that have been written exactly along the lines of what you said. And of course, again, I think aided and abetted by the gun control groups and their renewed rhetoric as well. So, what do you think happens? Do things settle down, and ultimately do we actually have to look at the facts, or how far can we go on this false premise, Jacob?
Well, I think, presumably this panel in Florida, when they take a look at the law, they're going to have to get down to specifics and say, well, does this case, this shooting with Trayvon Martin, actually teach us anything about the law? Is this a cautionary tale, and if so, why? What happened in this case as a result of this law that is troubling? That they're going to have to ask that. I mean, that's if they're doing any kind of serious examination, right? And I think they'll find that on the whole, it really didn't figure. That the Florida law did not figure in that particular case in any kind of decisive way, no matter what the outcome is. I mean, whether Zimmerman is acquitted or he's convicted, it's hard to see how Florida's law either dictated that outcome or was crucial in deciding that outcome. Especially because once he goes to trial, it'll be the usual process of trying to convict somebody beyond a reasonable doubt. So they'll have to ask that. But then I think there also will be getting into all of these complaints about, well, you had an increase, since the law was passed, there's been an increase in justifiable homicides. Well, no kidding. I mean, that's sort of the idea. The people find that alarming. It's quoted, people like Michael Bloomberg say, "Oh my God, look at how dramatically the number of justifiable homicides increased." As well, if the law were working as it's supposed to, you would expect that to happen, because that means that there are people who otherwise would have been unjustly convicted because they were acting in self-defense, but they weren't able to show it under the old standard. Now they can show it, and that's a good thing, assuming they really were acting in self-defense. Now, you have to get into the specifics of who are these people, what were the circumstances, in order to make a case that, no, some people are now getting off who shouldn't be getting off. I mean, that's really the thrust of the argument. That's the crux of it. They really have to look at the specifics. And by the way, the New York Times has been covering this issue for quite a while now, and I haven't seen anything there that really seems like strong evidence that there are a lot of miscarriages of justice as a result of this law. I mean, they cite in vague terms things like people getting into, bar fights or altercations as a result of a traffic accident, and somebody shoots somebody. Well, that alone doesn't tell you whether it's justified or not. I mean, you can imagine a fight that arises in those circumstances.
Right. Well, absolutely. I mean, I remember there was one case that I think someone referred to, one of the newspapers referred to, and they said that a guy came out and saw somebody breaking into his truck, chased him down, and shot him. That was how they initially described this, right? When you actually get into the weeds of the case, the guy came out, saw the guy stealing his radio, ran after him, didn't shoot him. The guy actually swung a bag of car radios at the guy's head and began attacking him, and that's when he drew his firearm and defended himself. But they leave out these crucial details, to paint this false picture. Well, as you say, hopefully, we'll actually get down to brass tacks, and we'll start to look at the facts of Stand Your Ground when the legislators in the task force starts to meet.
Yeah, I hope so. I mean, you really have to get down to specifics. You can't let people get away with these generalizations. And they're not really citing. Homicides overall are declining. So
absolutely,
it's not like. The critique says that people are violence is escalating as a result of the law where it wouldn't otherwise have escalated. Therefore, there are dead people who wouldn't be dead. I mean, that's the argument.
Right.
Well, where are they? Why is it that homicides are declining? If that's the case, as opposed to what the defenders of the law would say. Well, what's happening now is some of these cases that used to be classified as unjustified are now being classified as justified rightly, right? So you're moving from one category of homicide to another, but overall homicides are declining. It doesn't look on the face of it like there's a serious problem there. But again, you have to look at the specifics of each case and say, are we troubled by these details? Are people getting off when they shouldn't?
Absolutely. Hey, Jacob, thank you again, sir, for coming on the program. Great talking to you. Hope we can do it again soon.
Sure.
Jacob Sullivan joined us from Reason Magazine here on Cam and Company.